On the record, this is Dee. Starting with plaintiff, counsel, your appearance.
Good morning, Your Honor. James Jimmerson, bar number 12599 for the plaintiff, who's also present on my right.
Thank you.
And we also have Mr. Passer from a law clerk from our firm on Zoom.
Okay, appearing via Zoom. Noted. And sir, your name?
Appearing pro se, so for the time being.
Self-represented, that's fine.
I thought I was in the Zoom chat, but I tried to connect. I don't think I was able to make it then.
You're saying you also tried to connect on the Zoom?
Yeah, just because I want to just show a specific item that it physically.
Is it an exhibit?
It's specifically in reference to dosage and specifically about my usage of medication.
Okay, and it is.
I mean, I don't have to even like bring it as in because there's a court video, so like it's. I just wanted to state that I tried.
Okay, well, let's wait until we get there, see how far we get, because I want to address a couple things. First, I hear that there are observers here. Is that correct from your side?
Yes, Your Honor. My client's father and her best friend.
Okay, and they would like to come in and observe.
Yes,
Is there an objection?
Who's the best friend? No objection.
Okay, well, let's go ahead and allow them in to observe. Thank you. And certainly, it appears we have media presence here today, so this would likely be published. As he's bringing in our observers, I'll get started with our other matters. I know that in preparation for this, including even this morning, there's been a number of documents filed. Defendant, sir, you filed a document just yesterday on the 31st on Sunday. I can tell you that one I have not had the opportunity to review. I just saw it when I looked this morning, and it doesn't appear that you filed proof of service. I wouldn't expect, Mr. Jimmerson, that you would have had the time to review that one. That one is a motion to strike. Did you see that?
I saw it, Judge.
But we also have a number of status reports, exhibits, supplements. I want to remind you all, this was, I thought it would just be a simple status check regarding dad's supervised visitation, the child safety, just to ensure that visitation was happening per the parameters that we discussed and you put in place per the stip and order. So noting that, Mr. Jimmerson, I'll let you start.
Yes, Your Honor.
And ma'am, you can be seated, sir. You can be seated until your turn. Thank you.
The court wisely brought us back because there were a few things that took place during the last hearing. First and foremost, the offer by Mr. to decline ongoing visitation pending the evidentiary hearing in June. We certainly did not believe that was in the child's best interest. The court also agreed that it's not in the child's best interest. That notwithstanding, Judge, he has not exercised any visitation with the minor child on his visitation days. It has only been through the insistence of my client on her visitation days that he has been able to see. As a result, we certainly believe that the supervision and the restrictions on transporting the child should remain in place. As it pertains to the medical issues, the court will notice from the exhibits supplied by Mr. Joffrey in support of his status report. Exhibit 1 is a letter from Allison Palmer dated February 12, 2024. That was the subject of some of our concerns about whether or not it was an authentic document, Judge. That document, as the court has conceded. Mr. Pastor, can you please put on, share your screen, please put on Exhibit 1 from the status report. As the court will see here, we have some concerns about the authenticity of the document, most notably the odd font size and the odd capitalizations the court will see for prescriptions 2 and 3 clonazepam and trazodone, as well as the incomplete date for when Mr. patient there. Notwithstanding all of that, so assuming that is a genuine document, Judge, we've got a number of concerns. First of all, that this document was created February 12, 8 days before we had our hearing on February 20. So I don't believe it's necessarily responsive to what the court was concerned about. Most notably, the diagnoses information, because we see here 3 different prescriptions and yet only 2 diagnoses for those prescriptions. And based upon the testimony of Mr. or Judge Duckworth, that there was a 3rd diagnosis that we just don't have before us, Your Honor. So at a minimum, it would be an incomplete document. The other issues that we have, Judge, and I'm not going to belabor the point because I know the court has been very generous at this time, and that is the utter lack of following through on what had been promised, what had been agreed to. For example, Mr. did not disclose complete details of his diagnoses as demonstrated here. We don't have Mr. that's refused in his own status report to put his medical providers in touch with one another so that reading off the same hymn sheet, if you will. He has insisted on page 7 of his status report that, quote, no licensed physician, therapist, or medical practitioner of any kind concerning my privileged information will be sharing any information with one another or directly with the plaintiff or communicating directly with the plaintiff. The courts should want his doctors to be in touch with one another. They would have the same information so that they would be giving him the best possible treatment. Additionally, there was an agreement that Mr. maintained a journal of his medication, so we would know that he's taking his medication, what time, what dose, etc., and so that we'd be able to better understand the drug test results. As the court will see from Exhibit 4 of his appendix of exhibits, you see an actual diagram for, and I believe Mr. Pastor B. So that'd be the page 37 of the PDF and page 38 of the PDF. The court will see the graphs where we see the drug test results. Will you scroll up one more, please? I believe it's actually 1 page above that. Right? Yeah, there we go. We see here his Klonopin, and then before that we see 1 page up, Mr. Pastor, please. We see the Adderall prescription. And on test 1, we see very low test results. Then we see very high test results for test 2, and then a slight decrease for the Adderall, and a significant decrease in the Klonopin. And certainly a journal would help us understand what's going on when we see these drug test results, and so that his doctors know, is something, do we need to change something pharmacologically with Mr. So given all of that, Your Honor, and given the insistence by him not to engage in the supervised visitation except for when my client is there and offering it on her time, including, by the way, in her home, Judge, the court should maintain the supervised visitation. The one exception, Your Honor, is that because Natalie is now, I believe, approximately 7 months pregnant, and as the court has seen in various papers that have limited availability in March, that we rely upon Shiloh or another agreed-upon service, going forward.
Okay.
Thank you, Judge.
Okay. So you've heard those representations, basically asking that we keep supervised visitation in place. First, though, sir, just to kind of give you a little roadmap, if you could address the first point that you have not been exercising your right to supervised visitation, except for a mom's time, it sounds like in her home.
Okay. Thank you, Your Honor. I've been trying for the past month to see my daughter consistently. There are 3 supplemental, I think there are 3 supplements and an original 33-page order to enforce visitation. I've spent the entire month here, isolated, while there's a family emergency that I mentioned in India, where my family is going to see my grandmother dying in about 2 days that I don't know anyone here. I'm here solely for my daughter. I live here, I moved here solely for her.
Let me ask you about
So
that,
I've been
sir,
trying.
because of course you have my compassion there. Is it your intent to leave the country as well?
No.
So you're staying?
I'm here for her, and that was just the beginning.
Okay.
Let me just get to the point. As you can see in all of the supplements and the motion to enforce I filed, Natalie was very available. There was actually, Mr. Jimmerson stated in his opposition that something was curiously left out, and on a date of January, I think either the 20th or 24th of last month. Ironically, that was the exact same day that are shown in the exhibits added that I contacted Ms. stated, hey, because I was waiting to see if I needed to go to India. I said, well, hey, I don't need to go to India. My mom got her passport approved. I'm just going, so I've confirmed Natalie. Ms. canceled Natalie unilaterally and said we're looking for a supervisor. And then and there's also text message evidence with Natalie saying that she's available and she'll make herself available all month. The only issue is that like she couldn't do Sunday 1 through 4 and have to be court petitioned out. But we'd already established that there was flexibility for time at the end of the last hearing. The quote that I recall the best was on the 20th, the day after this hearing, and after enforcing stipulations based on my having already agreed to them and using Natalie, Ms. said, no, I don't agree to Natalie, don't ever mention her again. She's not neutral. The excerpt's in the, and secondly, Mr. Jimson even said in his opposition that before the court date, the morning of the 20th, Mr. already engaged Shiloh with the agenda of aggravating the issue. Eventually, so I started filing these motions. Eventually, I contacted Natalie, and eventually, he contacted me and said, well, now she's out of the state. So I contacted Natalie, like, hey, did you leave? Because she said, I'm available for the whole month. Whenever you need me, just tell me. She's even willing to drive me to go get her on Thursday so I can keep the Thursdays. But she said, listen, she made it very clear she doesn't want me anymore, and so I had to make other plans for the month. I'm sorry. That's why I pointed out that the order was being subverted by plaintiff, and it's like the documentation is so clear in these motions. I've just gone to great length, and it's just very depressing to be sitting in a house you built for your daughter alone and just writing stuff all month, and you can't see her, and the reasons why I keep changing. So I have tried, to put it that simply. And if there's any more clarification needed for the court, I can go into that. But I think there's some other points Mr. Jimmerson made about his information, that match test, and so to ask, we might want to use Zoom because I got the most recent test results then this morning, but I can only show them to you on my app if you want to see them. But there's a clear explanation in the status report and the supplement for the match test as to why this is a problem.
Let's go back a little bit, sir. If you can address Mr. Jimmerson's concerns about the authenticity of the one document, the first one he showed us in Exhibit 1 regarding the fonts and how there's 2 diagnoses, where's diagnosis 3, and the matchup with the medicines. Do you have any response there?
So as I mentioned in my detailed status report with my medical history since I was 19, with a lot of information. First off, again, according to Nevada Civil Code, like for claiming anyone to be impaired or anything of that nature, or concerning expert testimony about the proper formality of any documents. Mr. Jimmerson and I are not qualified to make any such statement, but I actually went ahead and emailed Department J a data history directly forwarding these documents from my medical provider and other documents of the same format to prove it. And my statement, I'm not sure if you saw those emails, but I sent them to Department J to show, look, there's data lineage showing that these are authentic documents.
Right, so I did not open those just because, according to my JA, and she's messaging right now, you did not, include Mr. Jimmerson on those emails as opposing counsel. So has he received all that documentation?
I believe he was included.
I was, Your Honor. I was copied Friday night, Saturday morning.
Okay, Friday night, Saturday morning.
These are authentic documents. And, I agree that the fonts look weird. I actually agree with them. They're complain to them. I don't know what else to say. Like, but any other information that Mr. Jimmerson wishes for? He also pointed out that I had shared some letter or something about that was dated before the hearing. That's because, as you know, we were in negotiations, and he stated that we had already come to an agreement and that we were already acting on it. Well, I was trying to act in good faith and share as much information as I could. And I contacted my doctor to share information and shared it. And that's why it's dated on that day. I didn't anticipate for them to withdraw from these negotiations and then violate the Nevada Civil Code and using discussions from these negotiations as evidence. So I say evidence because it's actually not substantial to claim that I'm impaired, but that's the reason for the date. So I think in terms of, I added a MedMatch supplement going over the MedMatch test and the results. Would the court like me to go into that, into the details?
No, you do not have to go into the details. Let me ask you this, sir, because we do have our full day trial coming up, our evidentiary hearing scheduled for June 21st, 9 a.m. That's just 2 months, basically, and discovery closes 30 days before. So the request is to keep supervised visitation in place and use Shiloh instead. I understand your concerns and representations about mom's actions. I'll see if Mr. Jimmerson wants to weigh in on all of that regarding her unilaterally canceling Natalie and basically forcing you into a situation with Shiloh. But sir, what is your request? Because I don't believe you had an exact answer, except for mom is trying to, per her actions, control all of this. What are you requesting for the next couple of months? They're asking that supervised visitation stay in place, that they use Shiloh, and that essentially the parameters that are in place per the stipulation, your agreements, stay in place for the child safety, at least, I guess, until we get to our evidentiary hearing. What is your position there, and what is your request for the next couple of months?
Typically, sorry, there's a point of the Nevada Civil Code I wish to bring up as an issue. Okay, all right. So my request is that supervised visitation be lifted. I demonstrated at length with the MedMatch supplement as to why not only were their readings completely off, and that their representations of your urine metabolite levels and use and drug dosage is completely is scientifically and clinically illiterate. I don't mean to disparage anyone. That's just what it is. I highlighted how Quest Diagnostics itself states that these are not for forensic tests. These are not, that the urine metabolite levels cannot be used to, and I highlighted those two portions, cannot be used to qualify whether there's impairment, and that there is also there's no way to determine dosage from these urine metabolite levels. And my statement was very clear beyond that. The type, also citing how often plaintiff and plaintiff's counsel have been just very confused and not able to read these tests. Even the deposition, not remembering that one was actually done correctly, how many were left. And their representation is even my representations are not admissible by Nevada NRS 5275.
I'm glad you said that because
Like,
I was going
either
there.
of them are.
I'm certainly not a medical expert,
Yeah.
and it's interesting because all this information is kind of here, but it's not an evidentiary hearing, just a status check. We don't have testimony from any of the providers that are listed on these documents. So the ask is kind of figure it out, and you're correct. Just as I can't take your representations regarding the medical expertise that would be needed to testify to these, I can't consider Mr. Jimmerson's either. It's basically demonstrative because we're here for a status check and they're saying, look, Judge, we can at least see that there's still enough to have concerns. You're saying maybe they're reading it incorrectly and there's not. But I guess my next question is then, sir, there's still a stipulation in order with your agreement to have these parameters in place, but now you're asking for supervision to be lifted. My confusion and concern there is their representation that we still have not really addressed, that you have not been asking to exercise your visitation during your time. If you can address why, sir.
I have been. That's blatantly false. I mean, I've been writing motions about how I'm trying to. Like, who sits at their house writing 33-page motions with 300-page appendices all day if they're not trying to see their daughter?
But with mom directly in your communication there, are you saying that besides the incidents where per your representations, she's canceling Natalie, you've been reaching out to her and she's denying visitation flat out?
She canceled Natalie unilaterally, and Natalie told me straight up.
And every time there's text messages or communications where you've reached out and she's denying to proceed with supervised visitation?
Yeah, there was so after I understood that Natalie was no longer going to be available, and she said clearly it's because that she's not going to accept me, which was news to me. And we did begin speaking to Shiloh. Neither of us had paid our half the night before one visit. I got a call from Miss that was just odd. Like, she was crying about having told she was finally going to get a Baba Day. See from how upset she is that she hasn't seen me. And I just had to look at her and say, I can't talk about it. Well, she's just like, why is there no more about this? And first of all, Miss accused me, saying, did you do something? I'm like, or did you do this on purpose? And thinking, I didn't even know how to respond to that. Likely, there was supposedly then communication by Miss to Shiloh. And again, she keeps copying or turning on this. She keeps doing emails with this. That's against our order. Mr. Jimmerson actually filed contempt motions against me for doing that before with our therapist. So, but it was just strange. Suddenly, she wasn't communicating with me. She was only, I got notice from Bianca from Shiloh Winery about the potential for paying last minute for Saturday. And just the fact that Mr. Jimmerson is being copied in his emails, he has not responded to my 3 motions or 4 motions. He's not responded to my request about the testing or payment for them. And now that there's suddenly a visit that they're not talking to me about, and they're giving me a certain cutoff time to pay for, it just made me suspicious. It was only 4 days ago, and I thought, let's wait to the hearing, because this can't go on. It needs to be lifted. Even my unqualified example can point out to you that the MedMatch test is a cutoff test. Cutoff 250 ml. My original levels were 312. That's barely above the cut. A cutoff test means if you're above this amount, it's recognized that you're taking the medication at all. That's how low my medication usage was. And I even told Miss Allison, hey, just bring my bottles of Adderall to court. I've got like 2 or 3 of them. I'm not taking them right now, really that much. Now, around.
Miss Allison, your
my
former
former
counsel?
attorney, yes.
Okay.
Now, anyway, the cutoff, so even using the plaintiff's logic, which isn't admissible anyway, but let's just say, for the sake of argument, for addressing concerns, that it's valid, that urine metabolite levels actually reflect dosage, which they conclusively have been stated to not do, which might show this valid discrepancy. And the latest test I got this morning is even lower. But the reason why, let's just say that it's true, 1-to-1, levels to dosage. Okay, cutoff is 250. I'm showing 312. That's barely detectable, and its federal cutoff is 500. So basically, according to that test, I'm not even taking the medication now, or barely taking enough to be registered. Now, my dosage for Adderall is 20 milligrams twice a day. So an 18x increase, about, I'd say 40, 50 days ago when the last test was taken, which was the third to last test was taken, would reflect not even a full half of the dosage daily, because it would have to be 20x to say, if it was really 1-to-1, to say, if the cutoff level is saying you're barely taking it, now it's 18x, well, it should be 40x, because I'm supposed to be taking 40 milligrams a day. So I'll tell you exactly what happened, what I think happened, even though it's not admissible. I wasn't sleeping much. My trazodone prescription was increased by Ms. Palmer. So I slept more. I felt more drowsy in the mornings. So I started taking more of my Adderall prescription. Now, I actually, out of just frustration, and I don't know those, but I brought with me my current Adderall book. It's right here. This is what I wanted to do. This is filled 217. Now, I haven't picked up my refill yet. It's been sitting there for about a week and a half at CVS, and I can prove that the next hearing because I'm that behind. This is what was filled a month ago. It's half full. These tests are not used by any court in the US. I've searched thoroughly, and I cited that the only record of these tests being used, of even being trying to be used by any court in the US, was a Quest executive requesting it for opioid abusers in New York, and it was denied. Since then, it has been made very clear by Quest Diagnostic these tests are not for use for any sort of dosage monitoring, forensic purposes, and fails to meet that criteria. And no court in the US, I found, has ever used these tests. And if you call their hotline, they say very clearly, we don't work with courts, we work with doctors. That's why when it was first ordered, Mr. Jimmerson told Judge Duckworth, yes, it's available to the public, there's no referral necessary. And they filed all those motions claiming that I was in contempt and that I was yada, yada, yada. It's because they assumed a court order was relevant, but these are medical tests. Well, Mr. Jimmerson sent Mr. Pastor, actually, with attorney from Smith Legal Group to confirm. I went in there with the court order and they said, we need a doctor's prescription, we don't care what the court says. And that goes to the other point of what Mr. Jimmerson is saying, that I won't let my doctors speak to each other. Actually, that is not true, and that's a purposefully misleading excerpt. I said it's legally nonsensical. I've spoken to my therapist about speaking to my doctor, and they're just like, I don't think I would be willing to do that. I send information to you, and they'll send information to me, which I've done through the status report, and I've even stated very clearly, I am open to all requests within reason from both plaintiff and any request by the court to submit, as I stated in my status report. But they are like, let's just say, okay, I do agree. I agree. Go ahead. the court can just force my doctor, can order my doctors to speak to each other. I'm betting they still won't do it. I don't think that's within the court's powers to do. And they definitely won't do it when I ask. So I don't have a solution to that.
Thank you, sir. Let me just jump in with a couple thoughts, and I'm going to go back and let Mr. Jimmerson have a response time. So what I heard you just represent is that your trazodone prescription increased, so you started taking more Adderall. You upped your Adderall dosage. Was that a recommendation, or did you just on your own up your dosage?
When I spoke to Allison Palmer, and I told her that I hadn't been even taking my Adderall as much because I hadn't been sleeping as much, I've been so stressed, especially considering all of this litigation. She knows about it because of the test being ordered. She's like, well, okay, you might feel a bit drowsy in the first few weeks, and yeah, just take your Adderall as needed. So I finally started actually taking my medication, the Adderall medication, more. Now, as I pointed out in the status report, there have been claims that I've been impaired since November, and that I'm unfit to drive, that I am potentially dangerous. If you look at the OSC motion, all of the claims that state the same thing were before November. After November, when I started taking these bed match tests, you see one uncontested behavioral order violation by myself that I would say uncontested. I was upset by something she said. I still should not have said that. One. That is an incredible increase in behavior. And also, I did not miss one visit. Incredible increase in reliability. I also drive about an hour or an hour and a half to get each time I get there. Because, as I mentioned in the status report, the plaintiff has been purposely taking me to school early to make it harder, to give her a longer trip, to shorten my 3-hour visitations to 30 minutes to an hour. And so I've been driving consistently for over an hour. I've been showing up to every visitation. It seems to imply that, and they've been claiming since during that time that I was impaired. So unless the plaintiff is implying that there is a positive correlation between impairment and increased reliability of visitation, and showing up on time for visits and behaving in a way that is in compliance with the decree, I don't think it's nonsensical, and I don't think that this should be allowed to continue. If the findings, or if the so-called agreement is based on this test that should never have been administered, frankly, it's not suitable for the court.
So, sir, let me just do this. Let me remind you, because I have the order here that's based off your stipulations and agreements, because we've been focused on the mid-mal testing and all of that. But first, in my mind, I'm thinking, when there's changes in prescriptions and increasing one, then increasing another, in my mind, that would support their request that perhaps supervised visitation is warranted, because no one really knows the impact on you when you're changing these prescriptions. When you are representing right now that you're drowsier, becoming more drowsy with the increased level of one prescription, and so then you're going up on the Adderall. So we have the depressant, then we have the Adderall. But I don't know the timing of this, but let's put that to the side. Per your agreements, and this is what they based off the agreement for, I want to be clear, these are not directives from the court. I adopted your agreements and your stipulations. So there's other things that Mr. Jimmerson mentioned, for instance, that you haven't addressed yet regarding, for instance, the journaling, so that they could understand the medication management generally and what dosages you're taking regularly. Regarding your doctors talking, don't necessarily disagree that just because there's an order, that without some action or probing, the doctors are just going to on their own set up a meeting and discuss things. I understand what you're saying there, sir. But we have several findings here that supports your agreements. So the not transporting the child is one thing. If you're driving, the concerns here by plaintiff have always been about the child. So you agreed that you wouldn't transport, and that's a separate condition there. Then also, you have the claim regarding mom unilaterally canceling Natalie. Per the order though, you agreed that the supervisor would be either Shiloh or Natalie, availability permitting. So the order does not state that you must use Natalie, and if there's a violation there, then that impacts supervised visitation. My reading of it is, and actually Shiloh is mentioned first, or Natalie, either would be fine, and that was your agreement. So I didn't have an understanding that Natalie had to be the person, and even if mom did something there, that would impact your availability and ability to have supervised visitation, that it was a clear either or. So as long as Shiloh was available, and they're asking to go with Shiloh now, due to Natalie being pregnant is my understanding and having decreased availability. The point I'm making is it did not leave you without an option for supervised visitation. So then we have the next order that you agreed to, that you would provide mom with your complete list of dates, that you would not be able to make visitation before April 1st, which is today, your proposed dates and times for makeup. I'm thinking so you all could discuss that, and any time that you had to miss, just look at a calendar and make up that time. I don't hear that that was necessarily offered to mom or done. Then we have, I don't want to go through the whole thing, there's a couple more agreements. We have our special hearing here, but I didn't hear anything about your agreement to journal, your agreement to go through ongoing drug testing, because I don't necessarily disagree with you, sir, that honestly, especially at a status check like this, looking at those reports is not necessarily helpful to the court in my determination to make a decision on your oral request to stop supervised visitation, which was your agreement, with all of these parameters in place. And it sounds like there's still concerns and issues, and the agreements here have not been completed in full. I don't necessarily need that. I can go off your representations to the court. So I guess for you, sir, I just want to remind you that this was a very specific, detailed order that at the last date, both parties, of course, mom through her counsel, said that you discussed this, these were agreements, and you decided to adopt it, and then went further and stated that you would decline visitation. Everyone said they want you, the court, mom, want you to be in a child's life as long as the safety plan is in place. I believe that the safety plan is still warranted. We were last here just in February, and we do have our evidentiary hearing set in June. I can tell you, your representations, thank you, but with the kind of overload of information, it needs to be addressed slowly in an evidentiary hearing, and anything that pertains to medical testing, the prescriptions, diagnoses, that's something that a medical expert needs to testify about. We all can have our ideas and assumptions about what these things mean. We don't really know, and it's not going to hold up, and that's why we would have an evidentiary hearing. I have to go back to Mr. Jimmerson now, because thank you. It was a lot of information. I have about a page of notes here from you, sir. Based on that, and considering his request that the condition for supervised visitation be lifted, counsel, any response?
Yes, Judge, just briefly, because I believe it's important that the court understand what the accurate series of facts are. Mr. Pastor, can you please bring up the Bates label SR Op 202? Now, if we look here, I think it's one page up, Andrew. You want 1144. So we're at, keep scrolling down, I think we're now a page down. Okay, we're going the wrong direction. Your Honor, we see Mr. about 12 hours after we conclude our hearing on February 20. Natalie is available 3/5, 3/7, 3/10, 3/21. We obviously have many more dates than that for Mr. Patient. As explained in our status report, 3/7 and 3/10 were unavailable because there was a trip that was pre-planned out of town. 3/21 was the day of operation where they took out her, and 3/5 was an available date that my client agreed to have down, Natalie. And if you look at, Mr. Pastor, please go to SR Op 70. We see at the top of the page at 5:53 p.m., this says, I agreed to Natalie once she gave her availability on the day that it works for me as well. So she's agreeing to the 3/5 when going to be in town and will not be subject to the operation. There was no question of whether or not my client was willing to work with Mr. on the matter. The key is, and the court was all over it, okay? He had other options too, right? This was not a situation in which it was just my way or the highway. To the contrary. We see the exhibit 1 from our status report. We see the string between my client copying Mr. and Bianca with Shiloh about an hour and a half, 2 hours after, I believe it was 1:30 in the afternoon that day.
And counsel, if I could just interrupt, I'm sorry,
Yes.
because it seems to be directly on point with what Dad was saying about mom not wanting Natalie, but here it appears, we read a little further in that same caption, she says, so even though I did not want Natalie, I wanted Shiloh, I compromised, I hope you will do the same and compromise and use Shiloh for other dates. So here, she is recognizing that she didn't want Natalie necessarily, it's the primary choice, but she was willing to do it.
Precisely, Judge. And that's, you know, that was the big part of it, is that, you know, my client can't get everything she wants. Obviously, Mr. can't get everything he wants. They have to work together for the betterment of this child. And what we see here is that my client is bending over backwards, like from the very outset, making sure they can get scheduling with Shiloh, right, so they can have an opportunity to see his child with the appropriate supervisors. This is not a situation in which she's trying to conceal, hide, or keep the child away. To the contrary, she wants her child to have a great relationship with her father. So I believe that was the one issue that we wanted to clarify for the court. The court knew that this is not a misdoing. This is certainly Mr. insistence or decision not to exercise his visitation. And I could go through, and for example, Your Honor, my client has already prepaid for her half of Shiloh. So this is in a situation in which Shiloh's waiting on her, not pardon, Your Honor. My client is doing everything she possibly can to facilitate this visitation. I could go on, Your Honor. Certainly there's not an hour and a half of driving. They live approximately 15 to 20 minutes away from one another. It's Rancho, the old Rancho down here in Alta, and he lives Midnight Melody, which is about 2:15. It's not a terribly long drive, but it's not a problem anymore because my client is doing the driving back and forth. So he's getting the benefit of a full 3 hours where he'd be enjoying those visits because my client drives home and picks and drives her back to her home. So we believe the court has appropriately gauged the situation and that there's and as my client is saying, she wants me to remind her, she wants him to exercise that visitation. So we appreciate the court's time, Your Honor. We believe that supervised visitation and the restriction on transportation should remain in place, as well as the remaining parts of the agreement.
There's something very important I need to clarify, Your Honor, as much as brief as possible. First off, Natalie, my contact with Natalie, the preliminary was after that day. That day is 4 days after the hearing, and there is, I'm not able to pull it up, I'm not on Zoom, but there are statements from her clearly saying that I am free for the entire month. I've made myself free available. I'm flexible except for these times, and it's available in the motion. So that is just patently false. But let's just be very quick. I'm going to read through first off this agreement. They keep saying we agree. The last hearing, and that's the biggest misunderstanding here, the largest. I wish to address the critical issue regarding to Jimmerson's reference at the last hearing that falsely implied that there was an agreement reached, which he said he referenced EDCR 5501 and said that which is used as certain communications purportedly for settlement negotiations. And he says he followed it to the letter, which obviously, if it's a settlement negotiation, and I mentioned this, like, the agreement was, I agree to all of this as long as we begin negotiations to settle this case. That has not been followed through. And that's the plaintiff's words themselves. And not only did they not follow through with it, but they used information gathered from feigned settlement negotiations to, he claims his adherence yet proceeds to reference out of context statements from these very negotiations to support his position. Notably, he cited the phrase, "Ask James what you want and you'll get it," attributed to discussions between our attorneys. This reference not only misconstrues the spirit of my communication with this, but also overlooks the essential fact that it was not in direct negotiations with Mr. Jimmerson, as my interactions were through counsel in compliance with standard legal practice. Like, obviously, like, I still had an attorney at the time. They're supposed to be negotiating a settlement, and that's what I assumed we were doing. So I would say, if the court wishes to assume that there's an agreement in place, then then the court should order that we settle this. Because that was the agreement, and in that case, I completely agree there was agreement. Otherwise, there are misrepresentations and there are violations of the code that should not be admissible in court. And just one more thing I want to go over here for that. And like I said, I'm happy to agree to anything they ask for if they fall through in their agreement. As they said, agreement. Even the Nevada Civil Code that stipulates the type of agreement, a settlement negotiation. Happy to do it, but we have to settle this matter, and I'm happy to do it for my daughter. I don't think the med match tests are going to give it any new information. They're $450 each. The client has been delinquent since November, even though they were ordered by Judge Duckworth to pay. They need to pay the balance. It's prohibitively expensive. But I'm going to go through this order. It's the order that I that it is order that I entered into agreement with Mom concerning parameters, which, based on this, it's only for settlement purposes, not for just to appease Mom's claims that I'm impaired. Also, my medication change happened in January. I have spent much time with my daughter since then.
Well, let me ask you this, sir, because I have the order right here before me pulled up. We don't have to go through it in detail again. But are you representing, because now you're representing yourself, are you representing that Mr. Jimmerson and plaintiff has stalled and you're not able to negotiate? Because I'm not privy to settlement negotiations, nor should I be, because I am the trier of fact at the evidentiary hearing. So I don't need information, of course, I'm just human, that could sway me either way at the evidentiary hearing. But are you saying that you are unable to discuss settlement with the other side? Have you given them a settlement proposal? Because I, of course, always encourage parties, and it's per our rules, 5.501 that you just named, I always encourage you to talk resolution and settlement, and that's probably in your best interest and in the best interest of the child. So you're saying they're refusing to communicate with you or come to the table in good faith?
Not only do they refuse, and they outright, the motion practice would not have happened. They outright, literally, like, that's why the motion practice happened, that's why there was any contention at all, whatsoever.
So are they refusing to negotiate, or are they refusing to accept your proposal? There's been no negotiations, they said they would have stipulated set of proposals for settlement. We were wanting just a number and what else they wanted besides the stipulations already mentioned. And throughout that weekend, Ms. kept threatening me again and again through messages I submitted in my opposition, saying that, look, if you don't do this, then we're not going to settle. If you don't do this, then we're not going to settle. They withdrew completely, and they filed a motion instead for part of the stipulations, and at the last hearing, Your Honor, correctly so, when Mr. Jimmerson had brought up a letter showing the proposal for settlement,
I also brought up, hey, we have a proposal for settlement, and they're not following it. And you mentioned correctly, well, I shouldn't be discussing that with you, but that is the issue. This would have never come before the court. I would have agreed to everything if they would have continued.
But since the last date, have you presented them with any settlement proposal or asked them to meet and confer about settlement?
I asked the one, she keeps going yes and no and no, and we're going to court and you're going to pay all my fees, and it won't be me who sends you to jail, it'll be the court who sends you to jail, and things of that nature. I can submit these issues, but yeah, listen, still, as before, the motion was filed in violation of the very code that Mr. Jimmerson stated, claiming there's an agreement. The motion would not have needed to be filed because that we were in settlement negotiations. They were terminated. It was a false representation. I'm open to all settlement. So I'm open to everything, as long as it's a settlement, as long as we're settling this case. That was the basis of the so-called agreement. Otherwise, there was no agreement.
All right, well, let's do this. Defendant is very clear that he would like to settle this case. I can only make a recommendation, sir, that perhaps you present a proposal to Mr. Jimmerson. I'm sure based on his reputation and being here before the court, he'll bring that proposal to his client. Sure, they would like to settle as well and not pay attorney's fees and continue to appear. So I encourage you and strongly recommend that you all focus on settlement. As far as our status check here today, what I will say is thank you both for your presentation of giving much more information than I typically receive at a status check, but that's what we're here for. This isn't a motion hearing right now. There are some things that have been filed but not served. So I can't see it, so you can handle that outside of court. But I am going to leave because we do have the valid court order, and it's enough evidence to support leaving that in place right now while you work on settlement. And again, if this matter does not settle right now, we're set for an evidentiary hearing on June 21st with discovery closing about 30 days before that date, which means before the end of May. So typically what happens is you're working on settlement, but you're also preparing for an evidentiary hearing. To my knowledge, that evidentiary hearing full date is still set, so we can get started if you all don't settle. But of course, I encourage that, and I expect Mr. Jimmerson will be talking to you about how to settle this case. And if I see, of course, a full stipend order presented to me, I'll review it as long as it appears to be in the best interest of the child and your agreement. I'll adopt it and we'll be done. We'll vacate that evidentiary hearing date. But that's if you all are able to present a full settlement. Okay, that's it for today. Thank you, everyone.
Your Honor, I just want to give one quick issue.
Okay.
This is a friendly reminder. We're obviously not seeking final motion and whatnot. Is behind on its child support from March 15. Just want to make sure that, as well as today, but obviously today is no weekend. So I just want to put that on the court's radar.
Extend it in the next 5 minutes.
Oh, beautiful. I'll remind you of your continual obligation for child support, of course.
Thank you very much, Judge.
Thank you. Have a good day, everyone.